p.m. in Memorial Hall, 272 Main Street, to review a proposed zoning bylaw as follows. 14589, recreational marijuana establishment zoning proposal. Parties wishing to speak in support of or in opposition to these amendments may do so in writing prior to a hearing or at the hearing in person or represented by an agent or attorney. Copies of the recreational marijuana establishment zoning proposal are available for review in the offices of the town clerk and land use office during business hours. Okay, now normally when I have to go ahead, they make me say something that I have to turn in ahead of time to sort of say at the town meeting before a bylaw or an article is introduced. I thought I would do that because I think it sort of may provide things a little bit better context in terms of this. So let me read this. In November 2016, the majority of the Townsend voters supported the legalization of recreational marijuana in Massachusetts. The planning board, and we the planning board has to vote on this, so I'm just going to caution that the board hasn't voted on this statement here, so I can't really say that they support it. But I believe I represent the board in saying that the Townsend Planning Board believes that the decision to allow recreational marijuana establishments in the town of Townsend is a very important decision and should be left to the residents to decide. Since the majority of the Townsend voters supported legalization of recreational marijuana, any restriction or ban on recreational marijuana establishments must be passed by a ballot election and at town meeting. In support of letting the town residents determine the fate of recreational marijuana establishments in Townsend, the Planning Board is submitting Article 29 to extend the temporary moratorium on recreational marijuana establishments until June 28, 2019. That's Article 29. The moratorium extension facilitates the opportunity for the Planning Board to petition the Board of Selectmen to include a ballot question restricting/banning recreational marijuana establishments in Townsend. The town election is currently scheduled for April 22nd, 2019. Assuming that the ballot question passes, the ballot question will go to town meeting currently scheduled for May 7th, 2019. Upon passing at the town meeting, the recreational marijuana establishments will be restricted/banned in the town of Townsend. The Planning Board is also submitting Article 30 to provide zoning restrictions in place for permitting recreational marijuana establishments. The rationale for the Planning Board to submit Article 30 is to ensure regulations are put in place for recreational marijuana establishments in the event the moratorium extension fails to pass or is rejected by the Attorney General. Assuming the temporary moratorium extension is approved at town meeting and the Attorney General, Article 30 permitting and by the Attorney General, Article 30 pertaining recreational marijuana will only go into effect if the town residents fail to pass a restriction/ban at the ballot in town meeting. Okay, so I sort of wanted to sort of give that context in terms of the Planning Board and our opinion that this is something that is rather serious to the character of our town and should be left for the voters to decide. All right? All right, so to basically get any, so I don't have any mandatory referral comments from any of the other town officers that to read tonight, so we did not get any. In terms of public questions or comments, I just want to read into the record one comment that we received from Kimberly Greenough. Did I pronounce that right? Greenough. Excuse me. I had problems with proper nouns. Kimberly, is Kimberly here by any chance? Because if she's here, then I'm not going to read her statement. Let her do it herself. All right. So this is to the Townsend Planning Board. regarding input for public hearing on 14589 recreational marijuana establishment zoning proposal. Townsend has a right to farm bylaw, which represents the will of the people, yet Town Hall refuses to embody the moral standard of Townsend General Bylaw, Chapter 34, which has been in place for over a decade, devoid of real support. For current farmers, the recreational marijuana zoning strips them of the opportunity to be more profitable on existing architectural lands. These farmers are the ones who do right by the local community and pass along benefits within Townsend. In return, the community planners put forth regulations to redirect new opportunities to outsiders who have no incentive to keep their business local. Townsend has nothing to be proud of when it comes to how it treats its dwindling number of remaining farmers. And bylaws like the recreational marijuana zoning present Townsend's commitment to a future of mindless installation of cul-de-sacs and common driveways where farmland once stood. My comment on this as a board member is as follows. First of all, we do have a vacant position on the planning board, and we would love to have Kim join us on the board so that we have, diverse opinions on the board, and we welcome her to participate. I wish she will. Second, as a farmer, grew up on a farm and what have you, I can tell you that my tenure on this board it's been the opposite in terms of cul-de-sacs and, McMansions. In fact, the board, in terms of all of its decisions, really has been more aimed at open space and importantly, affordable housing into Townsend. We have an aging population. We hate to see people that have to basically leave to be able to remain in Townsend. So we're sort of the opposite of increasing development in Townsend. And then my third point is, I don't agree with her statement that taking away or anything in this bylaw deals with our farmers. Recreational marijuana or growing marijuana is not like replacing soybeans or corn with another crop. It's like planting money trees. You just can't have marijuana growing in an open space for just by the nature of it. So that would be my comments, and I'll let the board, if any of the board members have any other comments that they wish to make on that. Okay. At this point, I would like to open up the hearing for public comment. Yes, John.
John Page, 8 Smith Street. Mr. Chairman, a procedural question through you to the town moderator, who I'm glad to see is here tonight. I believe that we could, on the floor of town meeting, rearrange the order of the articles being addressed.
Yes, there could be a motion to take the articles out of order.
Is it possible to do that in advance? My concern being, given the timing, both from the expiration of the moratorium and the holidays, that if this should go to a second night, assuming we do get a quorum for the first night, that this could become extremely problematic and leave us with no protection because the moratorium would expire as a matter of law and we wouldn't have a bylaw in place. Thank you.
Basically, the selectmen set the order of the articles on the warrant, and at town meeting, someone could move to take them in a different order, so that if this is a very concern of people, they want to make sure that they should make the vote on this and have a quorum, someone could move to advance this article and take that order from the other article. And if it's at the meeting,
Okay, question for John.
Can you come up to the microphone? Thank you.
Sorry, John. My question is, since you've made the statement so that everybody would know, what would be required to pass that, moving it out of order?
Well, someone would have to make a motion. Someone would have to second it. We would need to have something in writing, something along the lines. I move that the town take articles out of order and to take up Article, I think it's 28? Or
29 and 30.
29, and Article 30 first. And that we'd have a discussion, and then it could, if the town approved that, we could take the articles out of order.
Okay, is it a majority vote?
Yes, a procedural question like that, yeah.
Very good. So now the procedure, everybody here
Yeah.
knows what that
Yeah.
procedure is.
And,
Okay.
and follow up to John, there's no way of really doing it now. I mean, it has to be done at the town meeting. Yeah.
Okay.
But we can certainly be prepared and have something already drafted in writing to hand,
Sure.
you
Sure.
know, and then
Yeah.
we'll go ahead,
Yeah.
we'll do that.
If there is a, concern about doing that. I would just caution people that as this is a pretty exciting article, that they don't bring this one forward and then leave the room, okay? Because we still have other matters, and you can see Selectwoman King over there, sort of a little bit maybe perplexed that we don't want the other articles forgotten. So I just encourage everybody who's going to come because of this article, don't leave till the show's over, okay?
Okay.
Thank you.
Thanks, John. Thanks, John, for bringing that up, so now everyone can know the procedure.
Okay. All right, comments? Sure.
Kim Craven, 87 Lunenburg Road. I went ahead this afternoon and sent some comments along to the board through Beth, and I think that the board is doing a great job trying to protect our town. I've been just following what's happening in the state and seeing some things that other towns are putting in, that if we are going to the second part of what you explained, Lance, to vote on the bylaw itself, that there might be some things to add to the great work that you've already been doing, some things. There's one thing that I found in Worcester's about the storefront realtor shop, and it talks about the specific age limit, which of course is in the state law, and talks about if there's a co-location of medical marijuana at the same time. That is highlighted in yellow on the second page. The other thing that I noticed is seeing what's happening not here in not just in Massachusetts, but around the country. There's a lot going on with advertising of delivery, and notice that that wasn't included, and that we might want to put something in there that strictly prohibits that for the delivery service. You just mentioned the sort of grow facilities. One of the other things that I'm seeing crop up in other bylaws is strictly prohibiting greenhouses, so that no one comes forward with a greenhouse proposal. The other thing that I saw that was interesting is that within the bylaw itself, when it comes to the special permit criteria, that's highlighted on C2, that other communities are putting in specific times that the stores, the retail establishments, can never be open. So while you as the planning board would have times to be more restrictive, it might be helpful for us to know that it can never be a 24-hour operation, or maybe 11 o'clock that's in there is too late and you want to set it at 10. So that was just something that I saw in other bylaws. The other is under number 11, C, and that's just a more explicit control plan for odor, being real specific about the odor, smoke, vapor, fumes, gases coming from any establishment. The next one was just an enhancement under D, letter B, so D1, small letter B, that adequate security and storage, and that it could include cameras or identification technology. The other big area that I saw was under application requirements. And this was, I didn't create this, this is directly out of Worcester's. I really liked what they added about the pre-application meeting, all the things that they would need. So it's quite lengthy. That's highlighted in yellow there for you. And then the final thing that I saw is that while you mentioned the host community agreement, it didn't put the definition of it in the definition section. And so at the very end, there's a definition that's been pretty standardized around the host community agreement, and that's about the up to 3% of revenue that goes back to the town. So again, I know you guys have been working hard on it. I know it's unfolding before us throughout the state. There's new stuff coming out every day. So since your last one, those are some of the things that I saw. And like I said, I did go ahead and put it in writing so that you would have it. So,
Okay, thank you.
thank you.
Yeah. Correct. And Adam, do you have a copy of what Kim proposed? Okay,
Thank you, Ken.
thank you. Any other comments from the public? Excuse me, I think Kim moved first.
Okay, go ahead.
Cindy, I'm sorry.
All right, thank you. Cindy King, 1 West Elm Street. I am a selectman in Townsend, but I'm not here in that capacity. The Board of Selectmen has not voted on our opinion on this or any of the points that I'm going to make. These are personally, completely my own. My concerns about the bylaw that's presented, and I'm going off the one that was submitted for comments. I didn't even check to see if it's the same as what we have in the warrant. So my first quick question before I go on is the one that's public, that was sent for comments and publishing, is that the same as what's in the warrant?
No, I believe it's one and the same. Is Beth here? She can correct me on that.
I lost track of where Kim was going.
No, I
So,
mean,
I don't know.
the one
But
that's in
anyway.
the warrant, the one we have tonight is one and the same.
Okay, but you published the public hearing based on this one.
Correct, which is the same one.
It is the same, okay.
It's one
So
of the
no
same.
changes, okay.
Correct.
My concern is that the bylaw that's presented may actually turn out to, based on the way it's written without any changes, might effectively be a ban, because I don't see any way that we can have any place that would be legal to sell marijuana. And this appears to be the same as what you had presented back with the medical marijuana bylaw, which I believe is pretty much defunct based on the changes in the law on marijuana by the state. On the special permit approval criteria, you have number 3, marijuana establishments shall not be located within a 500-foot radius of all kinds of things. And basically, which you had even stated back when we had the medical marijuana public hearing, that your intent was to effectively ban medical marijuana. And again, at our selectmen's meeting last time, you stated that your intent was also to ban, that you're hoping that your goal is to effect a ban on marijuana in Townsend. And I'm really concerned that...
Do you want me to address your question?
No, I don't have a question. I don't have a question. That I'm concerned that the section that talks about all the places where children might even, in our imagination, congregate, which is no longer, my understanding is that it's no longer allowed to have these types of restrictions, and I think that it effectively bans. The recommendation from the Cannabis Commission is the only restriction would be a restriction of no more than 500 feet from K through 12, which we can go lower, we can be closer to a school, but you can't restrict it any farther. You can't say, 1,000-foot radius. It has to be 500 or less. And it's recommended that there's no other restrictions from that. But when I'm done, if town council could tell me if I'm completely wrong. But some of the restrictions here seem kind of strange, including any establishment license. We cannot, you want to ban it from any establishment licensed under the provisions of General Law, Chapter 138. In other words, licenses for on-the-premises alcoholic beverages, which we have alcoholic beverages being sold legally in a number of places that would be commercial. So it doesn't make sense to me that you can drink and not have marijuana available, unless there's a state law that says you cannot put those two together, which I have not been able to locate. So I think that these restrictions that are listed in this bylaw proposal effectively bans. And I think that, unless you can tell me exactly, give me some lot numbers on where this would actually allow, actually, still not a question yet, but I'm concerned that not only is the concern for town meeting whether or not the moratorium will, one, pass, or two, be accepted by the AG's office. I'm concerned that if this bylaw as it's written passes town meeting and gets sent to the AG is going to deny it also because it is too restrictive, in my opinion. But my opinion also, which is not based on law, but Kim Greeno mentioned in her letter to you about the farm community being able to grow marijuana. My understanding is under state law, it is okay to grow marijuana in a field as long as it's not, can be seen from the road and those kind of, there are restrictions regarding that. As you know, I've gone to a number of meetings from the state and consulting firms that advise municipalities on how to proceed with the marijuana bylaw or marijuana in your community, as this has been developing over the last couple of years. And unless they've changed it since my last contact, farming community, marijuana is, you're correct to say that marijuana is not considered agriculture. So we cannot treat it as an agricultural product, like soybeans and green beans or whatever. But I think it's worthy of discussion to consider that can we zone either a cultivation facility within an area that is actually zoned for farming without messing up like taxes or something. I think that cultivation and retail aren't the same thing. I believe they can't be sold in the same place anyway. I also, a thought I had as well, where alcohol is probably more people, alcohol is probably more dangerous than most of the other drugs that we have, and more people die of alcohol-related illnesses and injuries and arrests than marijuana, historically. So where we're having alcohol sold in a number of areas, including inside neighborhood commercial districts, I'm confused as to why we won't consider, or I would like to see us consider, allow it prior to the permitting process, that marijuana retail facility may be located within the same districts in which we're currently allowing alcohol to be sold, even not on the premises. In our neighborhood commercial districts, we do have alcohol being sold, beer and wine license or alcohol. So I think that it should be extended to the neighborhood commercial districts as well. I think that was all I have for now. Maybe I can later.
Okay, thank you.
And my only question was basically to council on whether or not my statements about the restrictions has any merit.
So before town council, let me just add a couple things. So first of all, when we go through and sort of set up zoning, we're looking at, we do not want to have establishments that are, K through 12. In fact, we want to go further than the state and say that it's pre-K for 12. We have the exact same zoning requirements where we use the baseline of what we had for medical marijuana and use them here. The one substantial change between medical marijuana and recreational marijuana, and let me back up, and by the way, the Attorney General reviewed our medical marijuana bylaw and approved it. So from a zoning standpoint, it's the same. We went into a little bit more detail to define where children commonly congregate. The other bylaw was a little bit, looser, where one could actually, make the point of, well, children congregate at a bus stop. So, you shouldn't have any type of establishment within 500 feet of a bus stop. And the Attorney General had found that that was a little bit too vague, and so we sort of went into more detail of where children congregate. So if you look at the basis that we did our zoning on, was basically saying, we really don't want to have a recreational marijuana establishment, where children congregate, well, children are, where there's a correctional institution. And mind you, we can't just pull out a map and say this is where they are, because we're not going to know what's going to be there in the future. We don't know that there may be a daycare center opening up, somewhere else. So we sort of have to define, these are the spots and this is the radius. We didn't go any further than what the state recommended. And then there are actually places we looked at applying this bylaw to our zoning map. And there are spots within Townsend where recreational marijuana establishments can be located. The district that encompasses our Old Town dump falls within that range, and I believe that there's some areas on Scales Lane or an area in Scales Lane that could fall within that. So we are not, in effect, zoning it out of the town. My comments. Anything other from the board members before we let Adam?
Just that at the last meeting before we planned to have the public hearing on the bylaw, one of the things we discussed was more of descriptive because of something the town council had told us. That's saying that it's 500 feet from K through 12 wasn't enough, that we had to have some examples. Am I saying that right or wrong? Okay, so that in fact was one of the reasons why we said we have to have a public hearing right away. We have to have it before the special town meeting, because you can make some tweaks to the warrant from the floor. And so our hope was to get input from the public as to what those tweaks should be, and we'll be prepared for that. And that was on town council's advice, because the Attorney General would not like it the way it is written now. That's why we're here tonight. So if you have suggestions for that, we're open to hearing them.
Okay. Adam, do you want to address Ms. King's comments?
Do you need the microphone?
I'll give you the microphone.
So thank you, Mr. Chair, and I'll direct my answer through you to Ms. King. So let me first just sort of preface my comments by saying regulating marijuana is a challenging task really for any municipality, and you're not alone in Townsend. We've got 351 communities that are in the exact same situation, trying to find a way to regulate, to zone, to license these sorts of establishments. And unlike other sorts of laws that have been in existence for decades, in some cases for centuries, we don't have that here. We have a law that was adopted 2 years ago, substantially rewritten and readopted about 8 months later, regulations that issued from the Cannabis Control Commission just back in January, so it hasn't even been a full year. And then we've got some guidance documents. If you go to the Cannabis Control Commission's website, you can see they've got about a dozen or so guidance documents for applicants, for municipalities, for municipal officials, for law enforcement. And so that's what we're basing the advice that we give as attorneys to the municipalities that we represent. We're basing it off of that limited information that we have. And much of what we say hasn't been tested yet. We have new information come in almost on a daily basis. In fact, not even a week ago, there were 3 moratoria that were reviewed by the Attorney General, and the Attorney General issued 3 separate opinions. In fact, there were 4, issued 4 opinions, striking 3 of the moratoria down and approving 1 other, based upon standards and criteria that were not entirely unknown to us, but it was really the first time we had seen them expressed in that way. So this is all new, and we're learning more information on a day-to-day basis. So, with that preface, I've reviewed the bylaw. I had an opportunity to speak to the chair about it a bit, and obviously came prepared to discuss it tonight. When we talk about a prohibition, what's so important in the marijuana context is that in any other context, you would have the ability, from a zoning perspective, to simply zone out a use. You could decide that you don't want big box stores in a particular district. You don't want big box stores in your residential district. And so you propose a bylaw that says no big box stores in our residential district. You present it at town meeting. Public hearing precedes that before the planning board. And if you get a 2/3 vote at town meeting, you've now zoned out big box stores from your residential district. It's that simple. With marijuana, it's more complex. Because you're a yes town, because you voted by more than 50% in favor of legalizing recreational marijuana, you've got this 2-part approach. You not only have to prohibit, if you choose to prohibit, any single type of marijuana establishment in a bylaw, or all types of marijuana establishments in a bylaw, you also have to accompany that by a ballot vote. And so the consequence of that is we have to be very careful about, in the context of a regulation like this, which does not seek to prohibit marijuana. You've already heard the chairman talk about how that might be something that is forthcoming in the future. But the discussion tonight is the regulation, the bylaw that's proposed. We've got to be careful that this bylaw does not affect a prohibition. Again, you want to prohibit it, there's a process for that. But that's not the objective of this bylaw. The objective of this bylaw is to regulate it, at least in the short term, until you are able to address that question of prohibition. And so I think the point that Ms. King was making is, if this bylaw affects a prohibition, even though it doesn't explicitly say we hereby prohibit marijuana establishments, if the effect of it is to prohibit them because the restrictions are so extensive that practically speaking you can't develop these facilities anywhere, well, that's problematic, because now you prohibited it, and yet you haven't paired this with a ballot vote, because you haven't gotten that far yet. And so when I review these bylaws, I look for two things. I look for potential, what they call facial challenges, and potential as-applied challenges. And so what's the difference? Well, a facial challenge is exactly what it sounds like. On its face, when I read this bylaw, does it appear to be a prohibition of marijuana? And you can look at that by looking simply to the location section. Where is this allowed? If it were allowed in one zoning district that is comprised of 10 acres, which is fully developed out, that's probably an effective prohibition because there's nowhere to put them. When I look at a bylaw like this and I see that it's allowed in 1, 2, 3 different districts, your downtown commercial, your outlying commercial, and your industrial, at first glance that says, okay, well, there's substantial enough land or properties available, buildings available, vacant land available in those districts to potentially allow for these facilities. Now you've got to pair that with a review of the other sections of the bylaw, like the special permit approval criteria, and again, something that Ms. King made reference to, including these various restrictions within which a marijuana establishment can't be located. 500 feet from residential districts, pre-K through 12 schools, daycare centers, etc. You've got to consider that, and then you've got to look in the districts where they're allowed and say, are there any areas that lie outside of those restricted areas where these facilities can still be built? And generally that's a task of your planning board, your town planner if you were to have one, your staff to look at the zoning map and to analyze whether there's sufficient area to potentially develop out these facilities. So this is the facial challenge. When you look at this bylaw, within the four corners, is it prohibiting these establishments? The as-applied challenge is more challenging. It's when you look at all of the prohibitions, all of the restrictions that are contained within this document, is the special permit granting authority going to apply these in such a way that applicant after applicant after applicant comes before them and is denied a permit to develop a marijuana establishment? Those can't be determined, those as-applied challenges can't be determined simply by reviewing the bylaw, and frankly they can't be determined in advance of adopting the bylaw. They tend to be determined after exactly that occurs. Applicant after applicant after applicant is denied, and the fifth or sixth applicant says enough is enough, it's very clear what you're doing here, and they sue the town on the basis that, as applied, this bylaw effectively is prohibiting marijuana establishments. I will say that, there are two ways to challenge a bylaw, or for a bylaw to be challenged. The first is the initial Attorney General approval that's required for any town in Massachusetts. Unlike cities, towns have to submit all of their bylaws once adopted at town meeting to the Attorney General for review and approval. And then there's the possibility, as a second means of challenge, that an applicant or other party brings a lawsuit against the town because an application is made and denied. The applicant appeals that on the basis that the bylaw is unlawful, and then it gets litigated and a determination is rendered by a judge as to whether or not the bylaw is lawful. The Attorney General standards are, I guess I would say, lower than the court standards, only because there's no case before the Attorney General. So for the Attorney General to look at a document like this and determine that it constitutes an effective prohibition, it has to really be clear within the document that it affects a prohibition of marijuana. Because again, there's no applicant that's come or a series of applicants that's come before the Special Permit Granting Authority at the time that the Attorney General is asked to review it. So the Attorney General will certainly look to the location provisions, will look to the special permit criteria, and will determine whether or not this constitutes an effective prohibition. In my opinion, based on what I see here and based on the discussions that I've had with town staff and the chair of your board, I don't perceive this to be an effective prohibition, because I think that there are sufficient areas available, maybe not a significant number, maybe not many areas available where these facilities could be developed, but a sufficient number that it doesn't constitute an effective prohibition as we stand today without any applications having come before the Special Permit Granting Authority. The one last thing I'll say is, a question was asked about, and I alluded to them a bit earlier, this 500-foot radius and the categories that are listed within the 500-foot radius. I know the Cannabis Control Commission's position on this, and I suspect it's what Ms. King was alluding to. She says she's been to a series of workshops or presentations, and the Cannabis Control Commission has been making these presentations across the Commonwealth to try to familiarize citizens and board and commission and committee members, municipal officials with this process and what they can and can't do. The regulations acknowledge that it's appropriate for municipalities, if they so choose, to reduce the restriction that is in the regulations that these sorts of establishments cannot be located within 500 feet of kindergarten through 12th grade schools. I know that the Cannabis Control Commission's position has been that distance can be reduced, but it can't be increased. And I also know, and this is consistent with what Ms. King said, that the position of the Cannabis Control Commission is that municipalities should not add categories, which was something that municipalities have frequently done and continue to do in the medical marijuana context. I'm of a somewhat different opinion, and again, this hasn't been tested yet. If the Cannabis Control Commission says you can zone these facilities wherever you choose as a municipality so long as you don't effectively prohibit them, that means you can do that any way you wish. You can restrict them to one zoning district, you can limit them to 2 or 3 or 4 zoning districts. You could create an overlay district with entirely new boundaries that is superimposed over existing districts within which these facilities are allowed. So if you're permitted to do all of that, then why can't you say, we're going to, instead of zoning it in that manner, we're going to identify facilities within 500 feet of which, 750 feet of which, 1,000 feet of which, we don't want marijuana establishments, but we're going to allow them everywhere else, or everywhere else within the limited districts that we've identified. So long as it's not an effective prohibition, how can the Cannabis Control Commission say that you're not permitted to do that? Isn't it the same thing as creating a map with 500 or 1,000-foot radiuses from pre-K, from daycare centers, from other marijuana establishments, from drug or alcohol rehabilitation facilities, all the categories in here, creating that map, and then everything that's not within one of those radii is your overlay district? Couldn't you do that? Well, Cannabis Control Commission said sure, and yet at the same time they say, but you can't add categories and you can't increase the distance. Doesn't make much sense to me. I've conferred with other attorneys who practice municipal law, who are familiar with the marijuana legislation, who are advising other municipalities, and they're of the same opinion. So there's no test case as of yet. I cautioned the chair when I spoke to him, particularly with this concept of facilities where children commonly congregate. That was terminology that was regularly used in the medical marijuana context, and there was some frustration with that. There were concerns raised by the Attorney General. There were municipalities who opted to be more specific, and my recommendation to municipalities in the recreational or adult use context is to be more specific, to identify those facilities because of the concern with any sort of area where a child may play, like a bus stop where they gather in the morning or in the afternoon, like a dance studio that might have programs for children. It can be very challenging to include a broad category like facilities where children congregate, because you may be effectively prohibiting these facilities because children commonly congregate in so many different areas. So the version here is somewhat broad, but not as broad as I've seen it. Could you get more specific? Could you eliminate it entirely? Certainly, but as it stands, as it's been published, the language is currently included where children commonly congregate, and that 500-foot radius is still maintained. Again, that's left to the discretion of the board and ultimately to the voters at town meeting. And with that, I'll turn it back to you, Mr. Chairman.
Okay, thank you. All right. Any additional comments, questions from the public? I'm sorry, you were in the queue.
Wayne Freitag, Joyce Street. I understand there's 75 towns in the Commonwealth where it's banned. And was that the effect of the election that they voted it down, or how is that possible?
Let me first address this, and I'll tell you the towns that I'm familiar with. So one of the things that when we were working on this bylaw that was, I think, important to me was to actually speak to our surrounding towns to find out what they're doing. So currently in Groton has recently, and I'm not going to use the word banned, I'm going to use the word restricted medical marijuana establishments. A medical marijuana establishment can be a retail operation, it can be a cultivator, it can be a manufacturer, it can be an R&D facility, it can be a test. Groton has restricted the medical marijuana establishments to only cultivation, test, and R&D. Lunenburg has gone ahead and I'll let Adam speak more since he's Lunenburg's counsel, whatever he can, but my understanding is that Lunenburg has passed a moratorium at their special town meeting, and that they're planning to put a prohibition bylaw at their annual town meeting to prohibit marijuana establishments.
Did they vote it down, the legalization of marijuana?
They just passed a moratorium.
Yep.
And they're planning, my understanding is they're planning to go forth with a ballot question to prohibit it, followed by that same question at their town meeting, and it's got to pass in both. Groton has already restricted it, and they banned recreational retail, and it's gone to a vote and passed, as well as passed at their town meeting.
Okay.
Now, if you want to add some more.
The only other town around that I knew did it was Sterling. The rest, seems like the whole north central Mass hasn't fought this thing at all.
Thank you, through you, Mr. Chairman. So I'm not aware of that number, 75. That may be accurate. It's a little difficult to pinpoint because even at this time of year, many communities are having their special town meetings, and so the number changes almost weekly. I think the number was up over 60 as of the conclusion of the annual town meetings in May or June for most communities that have banned it. It's also difficult because some communities have chosen to ban certain types of facilities. The way the legislation is written, if you choose to ban any type of marijuana establishment, you require, and you were a yes community, voted in favor of legalization, you require both the bylaw and the ballot vote. So many communities have said, for example, we want to ban retail, but especially in Western Massachusetts where there's much more open land, we want to permit cultivation. And so that would constitute a ban, but it's not a wholesale ban of marijuana establishments of every type. It's not simply because the communities that have banned it were no communities, because by virtue of voting no on the state ballot question, that didn't affect the ban in your community. What it does, however, is it allows those communities to simply adopt a bylaw that bans marijuana establishments or any type without having to also pair it with a ballot question. The additional step of a ballot question, which is unique to marijuana, as I said before, if we were talking about restricting big box stores, you could just go to town meeting and adopt the bylaw. That's what you can do if you were a no community. If you voted no against the legalization of adult use marijuana, you could simply adopt a bylaw by 2/3 vote at town meeting, and you could restrict or prohibit any or all types of marijuana establishments without also having to go back to the ballot box.
So that will be the result of when we go to the ballot next time if we vote it down, the legalization or whatever.
So we're talking about two different ballot votes, and I understand it's confusing. So when I refer to the ballot vote, and it's why I tried to be specific about the ballot vote on the question of legalization. That was a question on the state ballot a couple of years ago that asked whether or not in Massachusetts you as the voters would like to legalize recreational or adult use marijuana. That question has been voted on and passed by a sizable margin in Massachusetts, and so recreational marijuana is now legal in Massachusetts. That vote was also calculated on a community by community basis. So for each of the 351 communities, we've got a percentage yes and a percentage no. When the legislation was rewritten and the regulations followed, they differentiated between those communities that voted yes on that question back in 2016 and those that voted no. If you were a no community, very simply, you can just adopt a bylaw that prohibits those establishments in your community. If you were a yes community back in 2016, then you have to follow a two-step process. Not only adopt a bylaw prohibiting, but you have to go back to the ballot box with a slightly different question that now isn't asking you, do you want to legalize it in Massachusetts? It's saying, do you want to allow these establishments in Townsend? And you would have to vote in favor, by simple majority, in favor of that question as well. 2/3 majority on the bylaw prohibiting it, simple majority on the ballot question.
Okay. And I'd like to know where the police, fire, EMS, the Stones from Sterilite, and the school department all stand on that too. And that's all I have to say. Thank you.
Okay, thank you. Just to add to that, when I sort of read my little opening statement, again, it's the planning board's opinion that the voters should decide. And so we're planning to petition the selectmen to put a ban/restriction on our upcoming ballot in April. You have to come up to the mic. And anyone that has not signed the public sign-in sheet, please find it and sign it. Who has the public sign-in sheet?
It's right back here, yes, sir.
Oh, okay. So if anyone hasn't signed it, please do so at one point.
Good evening, everybody. James LeQueer, Chairman of the Board of Health, and I'm here on my own free will and accord because I felt it was necessary. The Board of Health has had discussions on this in the past. It has not been brought up currently to be here for this meeting, but the Board of Health is not in favor of allowing the growth and or distribution of marijuana in the town of Townsend, with the fact that we also have this serious vape problem going on in the Middlesex, Regional High, and it's out of control. Flavored vape products are out of control, and our children are not being led in the proper direction to control the health of their future and what is going on in the establishment of the state of Massachusetts throughout our country when it comes to the marijuana products. Cannabis is another word that's used there. Unfortunately, fortunately, I have never done that. I oppose the fact myself as an individual, and I just wanted to make sure I was here in time to make my opinion spoken, not on behalf of the Board of Health, but on behalf of my individuality in Townsend, and I'd like to see something brought in front of the Board of Health so that we can have some recognition of what's going to happen excuse me, as far as what's going to go on with regulations of any cannabis and or marijuana use in the town of Townsend. I have to be at another meeting, and unfortunately, I'm short on time.
Okay.
Thank you.
I just wanted to add the reason that we are putting a bylaw for recreational marijuana on the warrant, or the reason we are, is number one, if the moratorium fails to pass at town meeting, or if the Attorney General rejects our moratorium, we did not want to take the risk of having no bylaw in place until our April election. That is the motivation for the proposed bylaw. It is to basically, in the event that the moratorium does not remain in effect, we have some controls in place prior to the chance that the citizens can vote on it. All right, any other questions? Mr. Shank.
Mr. Shank, Turner Road. First of all, I want to thank the board for your efforts and hard work to try to protect our community. I feel we, as a community, we really need to make sure we protect the town. And as the elders of this community, we have to protect the children, our grandchildren, our children, our great-grandchildren. We don't need our community to be like Leicester and the other community that just opened their marijuana facilities, that they have a nightmare going, they don't know how to even fix it. This is a nice community. I've been here for 47 years. We need to protect it. I think what you're doing is correct. Unfortunately, I'll disagree with maybe what Ms. King said, that we should allow marijuana with package stores. I think that's just bizarre. And one thing we really need to remember, marijuana is prohibited federally. States can approve it, but the federal government still has not accepted marijuana as being legal. Thank you.
Hi, Sue Licio, 28 Ash Street, not here as a selectman, here as myself. I do have a question / concern. The way that the article is written right now, you were saying that possibly you'd make some kind of amendment to that on the floor based on input here. My concern is we've had the hearing, people have listened to why we're putting that bylaw on, okay? You've explained that real well. My concern is getting on town meeting floor and having more people confused by new language compared to what's on the warrant. That sometimes, in our experience, has caused confusion in the town meeting, and that confusion sometimes causes people to say, I don't want to vote on this, or I'm going to vote no on it. So I would be very cautious about what kinds of changes. I mean, I think town council looked at what you have already, and unless it's things that town council maybe thinks really should be fixed, I just think we've got to be careful, because I would hate for a vote not to be taken. I wouldn't want them to pass over it. Okay?
Thank you, Sue.
Okay, so to that, Adam, our discussion at the planning board meeting when we decided to have the public hearing, it was to get input from the residents. And I was under the impression that that area, or that vague area of the warrant, needed some tweaking, and that you would like to see us put something in there that would be more agreeable to the Attorney General. Is that right or wrong?
He already tweaked it.
So we're all set with, okay.
I'll let Adam speak.
Are you speaking about a particular section of the bylaw when you say it was vague or?
Yeah, where children congregate.
So let me read it just so it's clear to everybody in attendance. I'm looking at section C, subsection 3, further subsection C. It restricts the location of marijuana establishments, saying that they shall not be located within 500-foot radius from, and here's the language, any daycare center or facility where children commonly congregate. A facility is not, however, limited to a building. A facility where children commonly congregate includes, but is not limited to, facilities in which children gather for a particular purpose in a structured and scheduled manner, or which are dedicated to use by children, such as playgrounds, youth service programs, daycare centers, youth sports facilities, dance schools, and gymnastics schools. So that's the language.
That was changed from our original when we met, and then...
It was. Now, I want to be very clear in the guidance I'm giving. So, yes, it was even more vague before,
yes.
And I expressed concerns with it. Do I still have some concern? Is there still a possibility that the Attorney General may determine that that language is too vague? I think whenever you choose to use a term, facility where children commonly congregate, which was purposely a term that the Cannabis Control Commission removed from its regulations. They knew that the term existed because the term was used frequently and was in the medical marijuana legislation. They purposely removed it and simplified the radius calculation to only be from grade schools or K through 12 schools. So whenever you expand upon that, there is a possibility that the Attorney General may be concerned with it and may strike that portion of the bylaw.
Okay, so...
Let me just add something.
Yeah, I can.
All right. I just wanted to say that we as a board have a meeting on the 17th, which of course is already posted. We'll certainly take your advice into effect, where it's very confusing going in at the last minute to a town meeting with a complete red-lined warrant with changes. So I appreciate that, even though that we've had some very, very good comments. Those comments may be incorporated in at a later time, but ultimately it's the board to decide what amendments to make, keeping in mind that let's not confuse the electorate.
I would say, I agree with you. I agree with both of you. A bylaw can be changed at any town meeting. And so once the bylaw goes into effect and you see what the effects of the bylaw has had, it is very possible that the planning board or another board might come forward with amendments to that bylaw to make it better than what you're seeing it. I did have another question. Because the term was used that it would appear that we're banning this, and this could backfire on us. There are some places where, as Lance mentioned, where you could have a facility. My question is, in a town of 9,000 people, in a community such as ours, what is expected for us to find all these places that we would enable these establishments, whether they be for retail or growth or R&D or whatever? What are we as a community obligated to offer as an opportunity where we are not considered banning?
So, unfortunately, I don't have an easy answer for you because there's no test. There's no formula based upon population, based upon land area of your community. And, you know, this is not unique to marijuana. Years and years ago, this was addressed in the adult use context, which is a whole body of law dealing with adult uses and where those can be limited to in communities. So, for it to be an effective prohibition, the Attorney General would need to determine that you are depriving applicants of a reasonable opportunity to develop these sorts of facilities in your community. Is that 2-3 acre parcels that are available, or is that 25 5-acre parcels? Again, I don't have an answer to that question. I'm also not a planner, so when I see a bylaw of this sort, I review it based upon what I know the legal constraints are, and I take a look at your zoning and I see where your districts are in which you've allowed these facilities, and I look to see what's obvious on the face of a map or a zoning map in terms of where your residential district lies or where your schools are located, and try to look at, you know, the approximate 500-foot radius from those facilities, and I say to myself, okay, it looks like they've got enough area or they don't. There are mapping tools and there are planning departments in larger communities that have prepared and have presented at town meeting maps that show a radius around every facility that falls into these various categories. And that overlays that on a zoning map and can show the areas that are possibly available.
And we have those.
There you go. So kudos to you. So if you've got, you know, a fair amount of land available, vacant land available where these facilities could be constructed, if you've got existing buildings with vacant space available where these facilities could be retrofitted, then that will likely be deemed sufficient for the Attorney General. And again, I would not say it needs to be significant, particularly in a community of your size. The bar may be higher. There was a reference already made tonight to a review of, you know, Worcester's ordinance. The bar may be higher in Worcester. If Worcester is dedicating, you know, 2 parcels of an acre each to, you know, potential locations of marijuana establishments and saying that that's not an effective prohibition, it may be.
To the board, I just want to, Kim Craven, 87 Lunenburg Road. I did just want to address one of the comments about redlining, and I would invite the folks to come see the yellow highlights, because if we are going to put the bylaw in effect, and I'd love to hear town council's opinion on this, where there's silence on the delivery portion of anything that I said, I'd really love to see the town do that, and it's just a few sentences to add, not redline. The hours of operation, like you said, that can be site plan review, and that can be done in a later bylaw. So I think the most important one is addressing the delivery piece of all of the comments, because like you said, anything can be added at the Springtown meeting, but can't come on Monday. So, and again, if someone wants to look, we have some copies of that.
Thank you, Kim. I think that we probably think that there's a couple of good things that you mentioned, and certainly we can't think of everything, so that's what you do, and I appreciate your input on that safety part.
Every day there's something new.
Right. Right.
Right. John?
Thank you, John Page, Smith Street. You kind of preempted me. I was going to ask if there were going to be maps available so that people can see, because some of us know what the downtown commercial district is and so forth, but I think most people are visually oriented, and if they can see the maps, they'll be a little bit more understanding.
Yeah, and as I said before, the areas that fall is where the town dump is in terms of that district, and I didn't go over precise with my dividers, but also on scale lanes. The maps were put together by the assessor's office, and they're identical really to the maps that were done by our land use coordinator for the medical marijuana establishment. Yes.
I just have a couple comments, somewhat based on what some of the other comments have been. There was mention of some of the communities that have been banning, or what other communities have been doing. I think it's also important to mention that Ashby, that is a town much smaller than us, they're currently in the permitting process for 2 establishments on Ashby State Road, or Fishburg State Road, same street, one for cultivation and one for retail. So we're going to have sometime in the next several months, I don't know if they have to build a building or what they have to do for the retail, but Ashby will be selling marijuana in a retail establishment sometime in the next several months. So our residents are going to, that want to buy marijuana, will be able to go right down to Route 31 and purchase it. Also Fitchburg, I believe they have 5 establishments that they're working on, 2 of which are retail. One is, I don't know how they're going to do the parking there, but the Water Street Market Basket, if you've ever been there and tried to find a parking space to go to Market Basket, I can't imagine what it's going to be like to buy pot. But that's one of the locations, I believe, and the other is up on River Street. I think it's important that I know that the news was kind of scary when Leicester had their parking nightmare and their transportation nightmare, but I believe that they've gotten that a little bit better under control. But as we had discussed, that I attended a number of workshops, that the alleged nightmare that Leicester had was fully predictable, and is recommended by all the consulting and boards to talk about when establishments are coming on board, that parking and zoning as an issue, that parking and traffic has to be part of the consideration in the actual permitting process to make sure that there's adequate support for that. And it sounds like that was a little ball dropped, although Leicester and Northampton are the first establishments legally this side of the Mississippi, so they're coming from everywhere to purchase. So as stores or establishments open, the traffic will be less concentrated on 1 or 2 establishments. Salem, Mass. is going to be open up their retail this Saturday. And I think there's a lot for us to consider. One of the reports that I had got my hands on was a Department of Public Health report. They had a number of marijuana-related issues in it, but one thing that they did have, which was just done over last summer, was reported on in June to the legislature, that a survey of adults in Massachusetts showed that 21% of adults in Massachusetts consumed marijuana within the previous 30 days. So that says, generally speaking, give or take, 21% of the adults in Massachusetts regularly consume marijuana. So Townsend's no different. I'm assuming, and I think we would be wrong to say that we don't, but that I don't, but 21% of the adults in Townsend most likely consume marijuana on a semi-regular basis. 21% of our people are going to go to Ashby, they're going to go to Fitchburg right now. I'm sure we've had people that have gone to Leicester at least once, maybe Northampton, and maybe there's a bus trip planned to Salem Saturday, who knows. But I think it's also important to note that in the last few weeks, it's being reported almost daily what the money intake is in Massachusetts for the sale of marijuana, but over $2 million has been brought in the last few weeks to those two communities, the only two communities in Massachusetts that are selling it. Those communities get 3% of the take on the host agreement. That's a lot of money. And that's a lot of money that this town needs. And that's a lot of money that our residents are going to spend in Ashby and Fitchburg and wherever else retail is going to be allowed. So I think it's a very important financial consideration. And that is money that we could use to help support some of the issues that I agree that substance abuse is a big problem, Townsend and elsewhere. Having legal marijuana available to our residents that's not bought off the street, and that we tax it. We've been saying for decades, tax it. Here's our opportunity. And we can reap the benefits of it. We have a number of issues, and I think substance abuse is one. This town is doing absolutely nothing for substance abuse. Despite rumors, there's nothing going on to help with substance abuse, and we could use it. And we could use the money to establish something. Regarding putting some kind of marijuana facility at the Old Town Dump, as I repeatedly said, I've attended a number of workshops and a number of meetings and consulting firms, that one of the recommendations that's coming out of these consulting firms, as well as from Colorado and California, is that putting a marijuana facility on the back 40 somewhere, where it's out of sight and out of mind and out of view, is dangerous. It's dangerous for the people that are going to go, that work there. It's going to be dangerous for the people that are going to go there to make purchases, because it's off the beaten path. Nobody's going to know what's going on. And it's dangerous for our first responders and our police departments to go on a back road where it's just them. We don't have a major city police department here. We only have a couple cruisers on the road at a time. And to send on a regular routine patrol doing door checks by themselves in a place where people have said before that safety is a concern regarding marijuana establishments. And I think that's something that has been a recommendation of many of the firms, is that you need to have, the best thing to do is to have a marijuana establishment on Main Street where it can be seen and where daily seen. And these establishments, they're multi-million-dollar retailers. They have more security than you've ever seen in this town. There's probably more security in some of those establishments than they have at Fort Devens. That the security is immense, and it adds, they have the money to have security and to have the cameras and to have the, it really assists the other establishments, the restaurants or convenience stores that are nearby, and it's very helpful. So lastly, I do hope, I know there's some chatter and it's concerning, and it could be, I expect a lot of discussion on the town meeting floor, and I do hope that somebody, even amendments can be made on the floor, and I'm anticipating that there's going to be several, but that amendments are made, and because I think this bylaw does need some work. But I do hope that we can leave town meeting, the special town meeting, with a bylaw that's going to be approved by the townspeople. I don't think a ban is the right thing. I know that's not on the agenda for the special, but I really hope that we can come up with a workable solution that's going to benefit all aspects of the town. We are a yes town, and we had a record number of people came out to vote for that election. And over 2,000 people voted in favor of marijuana. And I don't believe, despite what, I know, Lance, you've said that you think that they voted for it elsewhere, but not in Townsend. I disagree with that. I don't think they were voting for an out-of-town vote. But anyway, that's all I have. Thank you.
Okay, thank you. Any other comments?
Connie Howard, Bow Street. I was just wondering, the two towns you mentioned, Lunenburg and Groton, has the Attorney General approved those propositions to one ban and the other to restrict and to, say, grow facilities or breeders or whatever? Do you know if those have been okayed or passed?
I'm going to let Adam, since she represents Lunenburg.
Yeah, because if you look at it, you see the taxes being taken in by these retail sales. So what happens if Groton has a grow facility, do they get taxed as well? Or if you deny everything, let's say we put a moratorium, nothing in Townsend, do we still get part of those taxes from the state or whatever? Is that from the general pool? Or is it more, hey, if you have a facility, you get a piece of that, and then the state's going to come back and, you know, or is everybody getting even cut? What happens?
Sure. So I can answer both questions if I may. So the first question, I can't speak to Groton. I'm not sure exactly what it was that Groton passed. I can speak to Lunenburg because I'm counsel there. Lunenburg adopted a moratorium. They did so originally back in 2017. They adopted a moratorium for through the end of 2018, so it expires on, it might have expired at the end of November. They had a special town meeting in November. They extended the moratorium through the end of May 2019. That extension of the moratorium has not yet been approved by the Attorney General. Not unusual. It usually takes approximately 30 days following a town meeting for the warrant as voted to be submitted to the Attorney General, and then they have a 90-day review process. So we may not hear back until March as to whether or not that's been approved. Mm-hmm. The concern and the reason, I think, and I don't want to speak for the chair or for the board, but you heard it said earlier that the reason this sort of approach is being advocated for, this moratorium in addition to a regulation, is to sort of pursue kind of a belt and suspenders approach to addressing marijuana at your upcoming special. And the reason for that is the Attorney General has expressed in the four recent decisions that they issued, has expressed some concern with moratoria that last too long if the town hasn't shown that it's undertaking a planning process. And so there's a possibility that once you've already gotten a year or 18-month moratorium, when you seek to extend it by another 6 months, there's a real possibility that the Attorney General may say no, and then you're sort of left unprotected.
Without those regulations in place, then it's just Wild West or whatever.
It essentially is, and I'll speak to that too, but let me address your other question. So in terms of the tax revenues, the legislation allows for municipalities to do two things. Number one, in a host community agreement, which is signed with the applicant, with the proponent for a facility, regardless of whether it's cultivation only or retail facility, there can be a percentage, up to 3% of gross revenues, that is collected for a period of up to 5 years to reimburse the town for costs that it anticipates incurring as a consequence of the permitting of the facility in its community. Beyond that, municipalities have the ability for a period after 5 years to also adopt a tax. And that tax can be up to 3% of gross revenues. And that tax would be a tax that goes into the town's general fund. So it doesn't get shared by other communities. It's not a tax that goes to the state. It's a municipal tax, a town tax, up to 3% of gross revenues. And those monies would come to the town. But the fact that you've got a facility in Ashby, or you've got a facility in Groton or another community, that doesn't benefit Townsend at all, because those tax revenues are going to those communities.
And so it sounds like eventually the moratoriums end. I mean, you can't just keep putting the moratorium on forever, perhaps.
And that's essentially what the Attorney General said in 3 of the 4 decisions that it issued last week. So moratoria are not new. They've been used in many other contexts. They were used on cell towers back before cell towers were entitled to all the federal protections that they now are. And consistently, the courts have said, the Attorney General's office has said, that the purpose of a moratorium is to allow a community to engage in a planning process. We don't want to allow these facilities effective tomorrow, because we need to undertake a process that could take us 3 or 6 or 9 months. We need to conduct public hearings, solicit public feedback, and then ultimately adopt a bylaw or other regulation that will address the issue, regardless of whether it's marijuana or something else. The courts have said fine, the AG's office has said fine, but at some point they expect that you've done something. So when you get a moratorium for 18 months, and then 18 months in, they say, well, what have you done? You say, well, we had one public hearing about 6 months ago. Okay, well, you had your opportunity. We gave you 18 months. Enough is enough. So we don't really know what's enough. We know that moratoria in Massachusetts generally have not been permitted for more than 2 years, more than a 2-year period. But whether 12 months, 18 months, or 24 months is acceptable in this context sort of depends upon what you can present to the state as evidence that you've been undergoing a process.
So it sounds like it's better just to get the regulations done and get it over with than the moratoriums. It's just a comment. Thanks.
Any other comments? Chief?
Rick Bailey, 87 Lunenburg Road. as I'm sure most of you know, I'm the police chief, but today I'm speaking as Rick Bailey, a resident with 43 years of police experience. When I think about recreational marijuana being sold, in my mind I think the boat has sailed. It's more likely than not going to happen. It's happening around us. It's happening in other places. Some of the things that I think about is since marijuana has become legal in Massachusetts, I've a number of times driving have been behind a vehicle and could smell marijuana. I'm sure many of you have had that experience. Smoking marijuana affects you as other drugs affect you. There are very little testing procedures for marijuana in the blood. You can test for it, but concentration and percentages are very different than it is for alcohol. Alcohol, you can get a very defined level. Marijuana is different. That will cause law enforcement some issues with prosecution. One of the other testing and prosecution. One of the other concerns that I have is it's going to be, I think, mostly a money business to start off with. And having these establishments that have a lot of marijuana in them, and they're selling it, from what I understand recently, there's one bank that is willing to accept their monies, given the federal issues that are around that. In my mind, I think that could cause some problems bringing money to the bank, traveling with it, having robberies, things like that, because you know where these establishments are. Illegal reselling is a problem and a concern of mine. You can go and you can buy the marijuana, assume that it's just marijuana because you're buying it from an establishment, but then inserting other chemicals into it and reselling it is a concern. And I don't know how you control that. I think there are many concerns. It'll be a challenge to address many of them. Thank you.
Any other comments? Okay.
I got one.
Oh, I'm sorry.
Billy Joe, Main Street. Somebody already stated, he's lived here 47 years. I was born in this town. I've lived here almost all my life. Like he said, it's out. It's coming. It's now, from what I understand, it's coming to Ashby. So it is here. So I would rather be prepared and know that, we have everything established. Like, for example, maybe for something to add to the bylaw would be that the establishments also put money towards rehabilitation and addiction. That could be something we could add into it so that we know that, from what I understand, we have rumors of this never happening. Well, maybe we establish that if it does come, it will happen. On the point of money transportation, I just heard, I work at a retail store. Sometimes we put into a armored car $1 million. I don't see that getting robbed. I worked there 4 years, haven't seen one person come up to that person with a gun with that money, so that's kind of a moot point. But I do agree with, there's going to be problems, but I'd rather face it and see that it's coming. The town could use the tax money in 1 week. Lester, I think, made $120,000 in 1 week. Now, I'm not saying that by the time that we have a store that we will be making that much money, but every penny to come into this town will help us. And I don't think shutting the door on retail or anything that will come into the town to make it profitable would be a bad thing. But we must face it and not shut the door and ignore it. So as a town, we should be smart, look at it, see what we can do, make it safe, and understand that it could be a good thing. And let's make something good out of it if it does come. Because if we sit here and we just talk about the bad, it's only going to be negative. Let's look at the positives of it, and let's face it head on. So thank you.
Thank you. I'm going to sort of direct this question to Adam to just validate what I'm about to say. I believe that for any sort of recreational marijuana establishment that's going to do business in this town in accordance with the bylaw, we have to have a host community agreement put in place. And that's something that the selectmen would do, and that's where there's an opportunity, and I think Lester did this, to have additional money provided to law enforcement for, security measures, and where you can have other items attached to, financially in that community host agreement.
So that's correct, and I appreciate you raising it, because I had said that I would get back to this, and then I didn't during my last comment. So we've heard a lot of concern from other communities that we represent, and I'm hearing it tonight with sort of the concept that, either you prohibit, which of course is not on the upcoming special town meeting warrant, and would need to be accompanied by a ballot vote anyway, or if you choose not to regulate, or you're unsuccessful regulating, or you've got a moratorium that either doesn't pass a town meeting or isn't approved by the Attorney General, then you're sort of caught with your pants down here. You're in trouble for the next however many months, be it 5 months, 6 months, 7 months, until you can get to an annual town meeting and hopefully do something about it then. And if you're unsuccessful, then once again you're exposed for a period of time after that. Certainly that's true to an extent, but I think that there is a bit of a fail-safe here in the marijuana context that too often is overlooked. And it may not give you comfort as a voter because you don't have the say, you're deferring to your selectmen, but then again you elected your selectmen. Your selectmen have the say as to whether or not they execute a host community agreement. And it used to be under the medical marijuana legislation that host community agreements were optional. I only know of one community that allowed a facility without a host community agreement, a medical marijuana facility, but nonetheless there was no requirement in the legislation that there be a host community agreement. When the adult use or recreational legislation was rewritten after it had initially been adopted, it provided for a host community agreement. And in fact, the regulations that were released back in January by the Cannabis Control Commission specifically contemplates and requires in every municipality where a marijuana establishment wishes to operate, be it cultivation, be it manufacturing or processing or retail, is required to have a host community agreement with the municipality. And there's only one way you can negotiate a host community agreement, and that's by getting the selectmen by majority vote to sign off on the host community agreement. And you're right, the host community agreement is where some of those goodies go. You generally can't include in the zoning bylaw provisions that would require monetary contributions by an applicant. That's contract zoning, it's illegal in Massachusetts. But you can negotiate as part of a contractual negotiation certain provisions in a host community agreement, like a commitment by the applicant to provide funds for the purpose of assisting with drug abuse or rehabilitation, to provide additional monies to the town to compensate them for additional law enforcement personnel or time that's required to monitor these facilities, or to provide an increased police presence around these facilities. Those sorts of monies can be recouped, and you can also get the applicant to make other certain commitments that may not be explicitly written into your zoning bylaw as it stands through that process as well. So that is something that's required. It gives your selectmen the opportunity to really stop any potential applicant at the door, even in the absence of any zoning that controls it. I'm not advocating for relying entirely upon that and not adopting zoning. I think the best way to go is to either adopt a zoning bylaw that regulates the substance, or to prohibit it. That's better than relying entirely upon the host community agreement, but it is a bit of a fail-safe.
Okay, any other comments? All right, I want to personally thank everyone for being here tonight and providing your input. I hope this has provided you with a better opportunity of what we're trying to do to go forward. Again, the planning board really felt that this was something that the decision should be made by the town residents. And so that's why we adopted the strategy of the moratorium, the putting in some regulations so it doesn't become the wild, wild west in the event that the moratorium does not pass or the Attorney General rejects the moratorium. So with that, I would like to entertain a motion to close the public hearing.
Make a motion that we close the public hearing.
Second.
Okay, all in favor?
Aye.
Aye. All right, thank you once again.
Thank you.
Yeah.